At 11:15 a.m. this morning, the New York civil fraud trial didn't pause for a procedural issue or break for lunch. It detonated. The courtroom was mid-argument when Judge Arthur Engeron slammed his gavel so hard it silenced everyone instantly. The defense team was cut off in the middle of a sentence, not because the judge was emotional, not because tempers flared, but because what the defense attempted to argue crossed a legal red line so severe that the judge had a duty to stop it immediately. The argument that triggered the explosion was simple on the surface and offensive at its core. The defense claimed this was a victimless crime. Their position was that since the banks were ultimately repaid, often with interest, no fraud occurred, no harm, no foul. That single assertion is what forced the judge to intervene, because allowing it to stand would have meant allowing a courtroom to become a place where arithmetic no longer matters and truth becomes optional. This moment had nothing to do with politics. It had nothing to do with personalities. It had everything to do with numbers. Cold, objective, documented numbers. The judge had already ruled that more than $2 billion in asset values were fabricated. $2 billion. Not a rounding error, not a difference of professional opinion, but a pattern of falsehoods large enough to function as a business model. I've spent decades dealing with financial fraud cases. I know the difference between aggressive valuation and criminal misrepresentation. What happened in that courtroom was a judge drawing a clear line. Facts matter here. And this case is built entirely on facts. There are two things the defense is desperately trying to keep out of public focus. First, a disclaimer clause they claim magically shields them from liability. And second, an internal bank document they hoped would never be seen. Both arguments collapse the moment you examine the evidence. Let's start where the judge started, with the document that underpins everything, the statement of financial condition. In fraud cases, this document is foundational. It's what banks rely on to assess risk. It determines interest rates, loan sizes, collateral requirements, and approval itself. If this document is materially false, then every dollar borrowed using it is tainted. Fraud doesn't require a loss. It requires deception, and the math here is devastating. Take Mar-a-Lago. In financial statements submitted to lenders, Mar-a-Lago was valued as high as $739 million. The defense claims this was based on its potential as a private residence. But here's the problem. When dealing with tax authorities, that same property was argued to be worth around $18 million. You cannot play both sides of reality. You cannot tell the government your property is worth almost nothing to reduce your tax bill, then turn around and tell a bank it's worth hundreds of millions to secure favorable loan terms. That's not creative accounting. That's a discrepancy of over 2,000%. That kind of gap doesn't happen by accident. It happens by design. Next, consider Trump Tower's triplex apartment. This is perhaps the most airtight proof of fraud in the entire case because it involves something that is not subjective at all: square footage. The financial statements claimed the apartment measured 30,000 square feet, justifying a valuation exceeding $300 million. But square footage is not an opinion. It's not a projection. It's a physical measurement. The actual size of the apartment is just under 11,000 square feet. Tripling the square footage allowed them to triple the value. And when you sign a document certifying that an apartment is 30,000 square feet when you know it's roughly 1/3 of that size, you are committing fraud. There is no alternative interpretation. None. Then there's 40 Wall Street. Here, the fraud wasn't about size, but income manipulation. The valuation was inflated by nearly $200 million by simply ignoring the actual expenses of operating the building. Costs were removed from the spreadsheet to artificially inflate net income. In forensic accounting, this is called cooking the books. It's not subtle, it's not sophisticated, and it's illegal. The defense tried to paint this as normal business behavior. Exaggeration, they argued, is common. Everyone does it, but that's a lie. Honest business owners do not triple the square footage of collateral on paper. Honest borrowers do not claim properties are worth 50 times their actual tax assessments. A single inflated number might be a mistake. An isolated error might be forgiven. But when this behavior repeats across multiple properties, across multiple years, involving billions of dollars, it stops being accidental. It becomes intentional. Intent is exactly what set the judge off. This wasn't about a small oversight or a careless misstep. This was a pattern, a deliberate scheme designed to deceive. The defense clung to one last lifeline, the so-called victimless crime argument, and it collapsed under scrutiny. Because here's the truth. The judge didn't slam the gavel out of anger. He slammed it because the defense's argument insulted the law itself. Under New York executive law, fraud does not require proof of financial loss. It doesn't matter if money changed hands. It doesn't matter if someone was technically hurt. The act of deception alone is a crime. Think about that for a moment. Here's a simple analogy. Imagine someone barreling down a school zone at 100 miles per hour. By sheer luck, no child gets hit, no parent panics, nothing physically happens. When the police pull the driver over, can he argue, "No one was hurt, so I didn't commit a crime"? Of course not. The crime is the reckless act itself, the risk, the intent to endanger. Fraud works the same way. You can hide behind the claim that no one lost money, but it doesn't matter. The law doesn't care. The act of lying, of intentionally inflating numbers, of building an illusion to deceive is the crime. And that's what the judge saw. He saw years of pattern, billions of dollars on paper, and a defense trying to pretend it was harmless. It wasn't harmless. It was calculated, deliberate, dangerous, and every attempt to justify it only confirmed the intent. That's why the gavel came down hard. Not because the judge wanted to punish, not because he was dramatic, because the law demanded it. Because the defense had underestimated the seriousness of their own actions, and because in the eyes of the court, deception is never harmless. Even if nobody loses anything, even if the public never sees the consequences, even if by some miracle the house of cards doesn't collapse immediately, the system protects against the act itself. And in this case, the act was undeniable. Intent, recklessness, deception. The judge recognized it immediately, and when he slammed the gavel, it wasn't just a sound, it was a message. The law will not be mocked. The act of fraud, like speeding through a school zone, is inherently dangerous, inherently criminal. It doesn't need a victim to be punishable, because the law doesn't only protect people, it protects the integrity of the system itself. And when billions of dollars and years of deception are involved, the system reacts decisively. Intent is not an abstract concept in a courtroom. It is the line between error and crime. And in this case, the line had been crossed. The defense's arguments were swept aside because in the law's eyes, the act of deception is enough to demand justice. No excuses, no loopholes, no victims required, and that ultimately is why the gavel fell. Financial fraud works the same way. It's not abstract, it's not harmless, it's real, and its consequences ripple far beyond a single transaction. When you lie to a bank to secure a better interest rate, you're not just bending the rules, you're stealing from the market itself. You are receiving capital you do not qualify for. You are undercutting honest borrowers who played by the rules. And that damage isn't isolated, it's systemic. This is what regulators call market integrity. A financial system only functions if participants tell the truth. If billion-dollar borrowers are allowed to lie, to inflate values, to manipulate numbers, as long as the check eventually clears, the system collapses. Banks respond to dishonesty by raising rates. Small businesses pay more, homeowners pay more. The cost of deception spreads to everyone. Everyone subsidizes the fraud. And make no mistake, the stakes are massive. We're not talking about a few dollars here or a single late payment. We're talking billions of dollars, years of manipulation, and a pattern that threatens the foundation of the financial system itself. The defense's argument, in essence, was a plea for special treatment. They asked the court to consider a new rule, a rule where wealth grants immunity, where honesty is optional if the check clears, where power shields you from consequences. The audacity of that argument is staggering, because the law does not and will not bend for power. The judge recognized this immediately. He didn't pause, he didn't negotiate. He slammed the argument down cold. Wealth does not rewrite the rules. Power does not erase responsibility. Every act of deception, no matter how well-funded or well-connected, carries consequences. The system is designed to enforce that truth, because without enforcement, the entire structure crumbles. And this is why the court's reaction wasn't just procedural, it was decisive. It wasn't about punishing the individual alone. It was about sending a message. The integrity of the market, the fairness of the financial system, the very principle of accountability cannot be negotiated away. There is no victimless exception for the rich, no loophole carved out for billionaires, no backdoor where intent and manipulation are ignored. Because fraud is not measured only by loss, it is measured by deception itself, by the act of bending reality to serve one's own gain. And when that act has consequences that ripple across the economy, touching every honest participant in the market, the need for enforcement becomes undeniable. That is the principle at stake here. Market integrity, accountability, rule of law, The defense asked for an exception, the judge refused, and in doing so, he reaffirmed that no one is above the law, not in business, not in finance, and certainly not in the courtroom. Every inflated number, every falsified document, every scheme designed to cheat the system carries consequences, because when billions are at stake and intent is clear, the law steps in, and it steps in decisively. This isn't theory, this isn't rhetoric, this is the reality of a system built to protect truth. No check, no wealth, no influence can override that principle. Fraud is a crime, intent is the trigger, consequences follow automatically, and the courtroom, like the market itself, cannot function if that truth is ignored. The defense's plea for a special rule failed because honesty is not optional, integrity is not negotiable, and the law will always act to protect both. And then came the document that shattered the defense completely. For weeks, they had spun their story. Deutsche Bank didn't rely on the financial statements, they claimed. The bank was sophisticated, they argued. It conducted independent appraisals, ignored self-reported numbers, made its own judgment calls. It was a clever narrative, a polished story designed to create doubt until the prosecution dropped a bomb. The bank's own internal risk assessment, dated 2014, related to the Doral Golf Resort loan. Just one sentence, one line that unraveled years of carefully constructed defense. The facility is being approved based on the financial strength of the guarantor. The guarantor, the defendant, and the financial strength, it came directly from the statement of financial condition. The very document filled with inflated numbers, fabricated numbers, numbers designed to deceive. Suddenly, the defense's entire argument collapsed like a house of cards in a storm. Their story of independent, sophisticated banking was exposed as fiction. This was no minor oversight, no technicality, no quibble over interpretation. This was a smoking gun. It showed in black and white that the bank relied entirely on the numbers the defendant provided, numbers that had been manipulated, numbers that had been deliberately inflated. The implications were staggering. All the claims about harmless exaggeration, all the assertions that this was common practice in business, they evaporated under the weight of that single sentence. Intent, which the defense had desperately tried to avoid acknowledging, was now undeniable. The bank's internal documents confirmed it. Every inflated square footage, every overvalued property, every false asset line wasn't an accident. It was part of a calculated effort to mislead lenders, to gain billions of dollars in capital under false pretenses. And the law doesn't care about clever stories or plausible deniability. The law cares about the truth, about the facts, about whether you intended to deceive. This sentence, the one line in a multi-page risk assessment, was enough to prove it. The courtroom felt the weight of it. The judge, who had been listening to weeks of arguments, paused. Every eye in the room understood the significance. This wasn't speculation. This wasn't theory. This was direct evidence. The defense could argue all they wanted about sophisticated banks and routine exaggeration, but the evidence didn't lie. The bank had relied on the very numbers the defendant had inflated. Every claim about victimless exaggeration, every attempt to portray themselves as a misunderstood business person fell apart. Intent was clear. Deception was proven. And the consequences, severe. Because this document didn't just expose the fraud, it exposed the defense's narrative as a lie. It showed that their argument wasn't just wrong, it was dangerous. It undermined the very integrity of the financial system they had tried to exploit. Every honest borrower, every lender operating in good faith, every business following the rules, they were all impacted by this deception. The courtroom understood it. The judge understood it. The prosecution had weaponized a single sentence to demonstrate the scope and intent of the fraud. The defense had nothing left to hide behind. And in that moment, it became painfully clear the game was over. This was the point where pretense ended, where narrative collided with reality, where the truth, in all its stark clarity, shattered years of artifice. The document was more than proof. It was the verdict before the trial even began. It was the evidence that intent wasn't just possible, it was undeniable. And it left the defense scrambling, grasping for anything to explain away what could not be explained. Nothing could erase the impact of that sentence. Nothing could rewrite what it revealed. The law, the market, and the integrity of the system itself demanded accountability, and for the defendant, that accountability had just become unavoidable. This is the smoking gun, the moment that changes everything. The bank relied on the personal guarantee. It relied on the claimed net worth. Without it, the loan terms would have been radically different or denied outright. Witnesses from the bank testified under oath. Interest rates would have been higher. Down payments would have been larger. Approval might never have come. Every financial projection, every deal structure, every risk calculation hinged on the numbers the defendant provided. And those numbers, fabricated, inflated, designed to mislead. That difference, the money saved through deception, is the ill-gotten gain. Roughly $168 million in interest savings. $168 million earned not through skill, not through business acumen, but through lies. That is fraud, plain and simple. One document proves it: reliance, materiality, intent, all spelled out in black and white. There is no gray area, no room for argument. And now, faced with this irrefutable evidence, the defense scrambles toward their final refuge, the disclaimer clause. Ah yes, the magic words in fine print. The clause says assets are estimated. The users should not rely on the statement. A legal shield, they claim, a get-out-of-jail-free card, except it's not. It does not give permission to lie. It does not erase the deceit. It does not absolve responsibility, because intent is the law's focus. The act of deception itself is criminal. The clause might warn naive observers not to rely on the numbers, but the bank did rely on them. It relied on them completely. Every loan term, every interest rate, every decision made in reliance on the financial statements proves that the deception was not hypothetical. It was real, it was consequential, and it was deliberate. The defense may argue estimates, disclaimers, generalities, but the law doesn't operate on clever wordplay. It operates on facts, on consequences, on the truth. And here, the truth is undeniable. The defendant's team tried every tactic in the playbook. They downplayed numbers. They claimed exaggeration was normal in business. They argued that banks were sophisticated, independent, and wouldn't be fooled. All of it crumbles in the face of a single internal risk assessment, a single document that proves the bank relied on the guarantor's financial strength, a single sentence that obliterates the narrative of innocence. And now, the final gambit, the disclaimer, fails because it cannot erase the reality established by the bank itself. Fraud is not measured by the fine print. Fraud is measured by the impact of lies, by the gains extracted from deception, by the trust betrayed. The judge, already observing weeks of posturing and obfuscation, sees it clearly. The defense has no escape hatch. The disclaimer clause is a mirage, a last-ditch effort to avoid accountability. But the facts stare back, unflinching. Billions of dollars at stake, tens of properties inflated, years of misleading statements, and a bank that acted entirely in reliance on false numbers. This is the textbook definition of material fraud. Intent is proven, harm is proven, and the law will not ignore it. Every misstatement, every exaggeration, every inflated asset line has consequences, because financial fraud isn't a victimless crime. It erodes the market, penalizes honest borrowers, and rewards deception. The defense's arguments are clever, verbose, and rehearsed, but the law doesn't bend for cleverness, it bends for evidence. And the evidence here is brutal, clear, incontrovertible. The smoking gun rests in the bank's internal assessment: reliance, materiality, intent, all in one sentence. And the disclaimer: it does nothing to change the truth, nothing to shield the defendant from responsibility, nothing to undo the $168 million in ill-gotten savings achieved through deception. Fraud is established, the law has spoken, and now the courtroom waits for justice to follow. In law, fraud vitiates everything. You cannot knowingly misrepresent facts and escape liability by adding fine print. You cannot sell a rock as a diamond and then point to a footnote saying, "This might not be a diamond." The disclaimer doesn't protect you, it proves awareness of deception. The judge ruled explicitly that these disclaimers do not shield intentional fraud. They were vague, non-specific, and incapable of covering blatant lies like tripling square footage. By leaning on this clause, the defense is effectively admitting the numbers were wrong. They're no longer arguing about accuracy, they're arguing irresponsibility. That's legal desperation, and the consequences are severe. This isn't just about money, this is about the corporate death penalty. Under New York law, persistent fraud allows the state to dissolve a business entirely. The judge has already ordered the cancellation of business certificates for key entities. That means loss of the legal right to operate. A court-appointed receiver could take control within weeks. Properties managed, accounts seized, assets sold, the empire dismantled piece by piece. Then comes disgorgement, not a fine, but a refund. Every dollar gained through fraud must be returned. If cash isn't available, assets are liquidated, buildings sold, names removed, appeals will follow, but appeals courts don't rewrite facts. And the facts here are ironclad. Square footage, tax assessments, internal bank emails, numbers don't lie. If this behavior were allowed to stand, The banking system would become a casino. Trust would evaporate. Costs would rise for everyone. That's why accountability matters. This process is slow. It's technical. It's tedious. But eventually, the check comes due. That's not politics. That's arithmetic. A square foot is a square foot. A dollar is a dollar. Truth doesn't care who you are. The judge's gavel wasn't an outburst. It was reality asserting itself. And this story isn't over. I'll be tracking the appeal, the receiver, the asset sales, because verdicts are only the beginning. Judgment is satisfied at the end. Facts matter. Tell me in the comments, should the penalty stop at money or should the business license be revoked entirely? Because today proved one thing clearly. You can bluster in public, but you cannot bluster a balance sheet.